If you're named as executor in a will, you may first need to apply for probate. Probate is the Supreme Court's recognition that the will is legally valid and that you, as executor, are authorised to deal with the estate. There are three main types of probate. The first is a grant of probate. This will occur where there's a valid will and the executor named in the will is the one applying. Then there's a grant of letters of administration of the will. This is where there's a valid will and someone other than the executor named in the will is applying. Lastly, there's a grant of letters of administration on intestacy. This is where no valid will existed and the authorised person will be an administrator. Today we're going to focus on the steps involved for a grant of probate. So where a valid will exists and an executor named in the will is applying, the executor would need a grant of probate. A solicitor or public trustee can undertake the application for probate, or the executor can do it themselves. Basically, there are 5 steps involved in applying for probate as the executor. The first is to advertise your intention to apply. Second, you must provide a copy of the notice of intention to apply to the public trustees. You must then wait 7 days after the public trustee receives the notice to file your application. Third, you must give people time to object. You must wait for 14 days after the notice appears to allow people time to object to your application. After that, you can go ahead and file your application with the courts. The fourth step is to prepare all the documents for the application, and there are several forms which need to be completed, including the application for probate and an affidavit in support. You'll also need a death certificate and a photocopy of the last will, as well as some other forms. Once you have all of that together, you would file at the Supreme Court. You can file in person or by mail at the nearest Supreme Court to where the deceased lived. In Queensland, that's Brisbane, Rockhampton, Townsville or Cairns. The court will then examine the documents and, if in order, issues the grant, which can be received back in person or by mail. And the court may take 4 to 6 weeks to process the grant. So do you need to apply for probate? Probate may not be required if the value of the assets in the will is fairly small or if real estate is being transferred to a beneficiary named in the will. At this point then, it's important to understand what assets are included in the will or the estate, as any assets outside of the will or the estate do not require probate. So assets in a will include things like assets owned individually or tenants in common, whereas jointly owned assets are outside of the will. Superannuation may be in or out of the will, depending on whether there are valid binding death benefit nominations and what they say. Life insurance can also be in or out of the will, depending again on ownership and beneficiaries nominated. In the will are shares in a company. Out of the will are assets held within companies and assets held within family trusts. So let's look at some probate case studies. Robert has passed away with a valid will. Susan is Robert's executor and determines that his estate includes the following assets: a bank account of $32,000, a refundable accommodation bond for the aged care home where Robert resided, valued at $550,000, and some personal contents of around $5,000. As the bank account is greater than $30,000, it is likely the bank will require probate. And Susan has also contacted the aged care home and they state that they will require a grant of probate. Therefore, Susan must obtain a grant of probate before she can execute the will and deal with the bank and the aged care home. Joan has passed away with a valid will. Her husband Bill is executor. Joan owned the following assets jointly with Bill: a bank account of $32,000, a $1 million home, a vehicle of $110,000 and a share portfolio of around $1 million. As all of the assets are owned jointly, on Joan's death, all the assets will automatically transfer to Bill under the law of survivorship. It is likely that Bill will only require a certified copy of the death certificate to have the ownership change from joint names to his name. So as you can see from the above case studies, it's not necessarily the size of the estate that determines probate, but rather the type and ownership of assets. Interestingly, regardless of the assets involved in the estate, if the deceased was completing tax returns prior to their death, it is likely that a grant of probate will be required. This is because legally your accountant cannot access information or attend to taxation matters for the deceased or their estate until probate has been granted. We have further resources on probate on our website at alton.net.